When corrupt cops finally face justice, their reactions are unforgettable. Here are officers who thought themselves above the law and were handed life sentences for the most unthinkable crimes you can think of. So make sure to stick around till the end to see the worst of them all. But first, let's take a look at this officer getting humbled in the most humiliating way.
In 2014, Lisette Gonzalez was charged with driving under the influence after being observed drinking beer while driving. Officer Michael Wagner testified that he witnessed Gonzalez consuming alcohol and subsequently arrested her. After the verdict was reached, Gonzalez's attorney made a final plea.
Your Honor, not enough evidence presented for the jury to find the verdict that they did. They didn't do all the field sobriety examinations that should have been done. I respectfully ask that this court grant the judgment notwithstanding the verdict.
According to the attorney, Gonzalez was not given a breathalyzer, and neither had her blood drawn for testing. Based on this, he asked the judge to overturn the verdict.
This isn't a purely circumstantial case, and so I'm going to deny the motion for JOA. Now, we have this other case for driving while license suspended.
Next, the judge brought up the issue that Gonzalez was driving with a suspended license, but that only happened because the arresting office, Wagner, Ayers, submitted a false report. When Wagner's attorney tries defending him, though, the judge loses his cool.
I want to be enlightened.
It was a mistake, admittedly, by Michael Wagner.
I know.
Testified to that today.
He caused her to have her driver's license suspended for at least a few months for nothing. So are you going to null process that case, or am I going to get mad at you today?
Perhaps you can get mad at me, Your Honor, but at this point...
Why wouldn't you? Wait a minute. Did you hear the uncontroverted testimony of this officer?
Your Honor.
Then I want you taking him up on perjury.
Your Honor.
Will you take him up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied on a sworn
Absolutely
citation.
not, Your Honor, and that is not true.
I'm dismissing. I am dismissing this charge. No, I'm dismissing the charge.
The attorney was trying to be assertive with a judge. They don't even have the decency anymore to be respectful, but the judge handled this spoiled woman pretty well.
This whole case was fishy, and I have no idea how they... You know what?
Their address on file.
You know what?
The state intends to amend
I'm
the
granting.
charge and proceed on
I'm rescinding the sentence. I'm granting the JOA.
I agree with the state's decision on
I'm
the
granting
other
the
charge.
JOA in fairness.
In fairness, because you don't like the state's decision today, Your Honor, on the case?
No, you're not. Now that I consider what Officer Wagner testified to and how many times he basically tripped over himself just to arrest this lady with no real probable cause. You're done. Motion JOA is granted.
And you're not going to provide a written order on that?
Nope. You want to appeal me? No.
Thank you, Your Honor.
The case should have never been done. Never.
Thank you for letting us know that, Your Honor.
It's mind-blowing that some of these attorneys will go to any length to protect the evilest of people. Thanks to the judge's sensibility, Gonzalez walked out of that room free of all charges. If you think this cop had it bad, then wait till you see this next case where an evil cop got a sentence that rendered his life essentially over.
We have surgically removed the cancerous officers from the Edison Police Department.
The officer in question was Edison police officer Michael Dotro, who was responsible for various plots to harm other officers and firebomb the house of one of his supervisors. Yes, you heard that right. This guy actually did that. Then, on September 7th, 2017, Middlesex County Court in New Brunswick.
Everyone to understand where I'm coming from with regards to this, especially if there's going to be any appellate review of this sentence. I want those judges to know the sentence to be imposed in this particular case is because Mr. Dotro, through his conduct and his admissions, spanning from 1998 to this year, represents the worst that we can possibly expect from someone in our society. Yes, he's caused very specific damage to Captain Endurple and his family, to Ms. Zog, to Ms. Dotro, to his own parents, to his families, to his brothers, after he's walking out the door to spend the next third of his life in prison, is allowed people a basis to say that our system of justice has no integrity. How could it, when we've allowed this particular individual like him, here in Middlesex County, here in Edison, to do the things that he's done? similar to what we see on the news every day from other parts of the country.
The judge was a perfect example of how criminals like that officer should be treated like they are a disease that should be eradicated from this planet and despised as much as possible.
Because of him and people like him, victims are afraid to come forward to be part of the criminal justice system and get the relief that they're entitled to from being victimized, because they have no faith in it, because they don't know who to trust. Even more importantly, we have other individuals every day who put on a badge which represents honor, service, and integrity. And without question, go out there every day, leave their family behind to protect an entire community with hopes that they can make it through the day, through the end of their shift, so that they can go back home to their family and lead a normal human being life, because the life of a police officer is not a normal human being life.
It's really sad to say this, but that badge no longer means service and integrity. It has become just another means for bullies like Dotro to fulfill their egoic desires. After this, a prosecutor, along with 2 chiefs, announced the final sentencing for Michael Dotro.
In May of 2013, I stood right here and we announced the charges against Michael Dotro, very serious charges, and at that point I was bringing the prosecutor 2 weeks into the job. Since that time, I have worked with the Middlesex County Prosecutor's Office, Chief Bryant specifically, the Edison Police Department, many of its officers, and what we have done is we have analyzed what exactly was going on in Edison Police Department, and we have surgically removed the cancerous officers from the Edison Police Department. The Edison Police Department is a much different place than it was 4 years ago. Michael Dotro has now been sentenced for some very serious crimes that legitimate police officers find absolutely repugnant. We've gone back and we've looked at other officers at the Edison Police Department, and frankly, we've worked hard to clean shop. 4 other officers were removed for malfeasance that were directly tied to the Dotro investigation. And in addition, 3 others were removed for other acts that were inappropriate as well.
This is why it's essential to raise awareness about the disgusting actions of officers who abuse their power, because eventually, our voice reaches the top.
There's a new tone, there's a new day in Edison Police Department. All of the police officers who've gone the Edison Police Department uniform are proudly serving its citizens and everybody who comes through Edison. They're doing a fine job and they're serving with integrity. And that's what the County of Middlesex should know today. The Edison Police Department is a much better and different place than it was 4 years ago. And we're happy with the judge's rendering of the sentence today. Thank you.
Michael Dotro was an Edison cop for 10 years before his arrest and conviction. He was sentenced to 20 years in prison following his guilty plea. This cop got served pretty well, just like this next one who couldn't even admit he was guilty.
I've already ruled. I've already ruled at this point in time. We're done at this point in time.
During a hearing in Breckinridge County, Kentucky, Todd Pate, the former sheriff of Breckinridge County, appeared in front of the judge after he was charged with operating under the influence for the second time. As the hearing proceeds, Todd does something pretty strange.
This time is it your desire to change your plea from not guilty to guilty?
Do I have to answer that yes or no, or can I make somewhat of a statement?
That is a yes or no answer, sir.
Will I have the opportunity to say anything further?
If it is your intention to change your plea from not guilty to guilty, certainly you'll have an opportunity to make any statement. But if it is not your intent to enter a guilty plea at this time, then I'm going to set your case for jury trial, and you're going to stop wasting my time and everybody else's time this afternoon.
Ma'am, I'm not trying to waste your time.
Then is it your intention to enter a guilty plea at this time or not, sir?
No.
Todd had the option to plead guilty and reduce his sentence from 15 years to 75 days, and he still struggled with it. If that isn't stupidity, I don't know what is.
Why am I wasting your time,
Mr. Chambers, what is the Commonwealth's position at this time, sir?
Your Honor, we would move to revoke the defendant's bond at this time.
I believe I'll just let him answer that question if it pleases the court.
All right. So, Mr. Pate?
Can I say a few things, or?
I need to understand what it is that we're doing here today, Mr. Pate.
Yes, I had every intention of coming in here today and entering a guilty plea. It's difficult for me to enter a guilty plea for a lot of reasons, and I don't want this court to think that I am trying to minimize any responsibility that I had in this situation that occurred.
The former sheriff was doing all that drama so that he could prove himself right. In other words, being right was more important for him than spending less time in jail.
I feel like I'm being very much into doing something that's not right. And I want this court to know that Todd Pate holds himself responsible for everything that he did. But it's hard for me to lay down and plead to felony charges that don't apply.
Is it your intention today to enter this guilty plea?
And if I could address...
Okay, this is either a yes or no. Are you going to enter your plea or not?
I guess everybody thinks it's funny. Let me just plea and get it over with for everybody. Plea to something that I absolutely do not feel good about, but I don't want you to try to send me to the penitentiary for years and years. If you can sleep with it, I can sleep with it.
I think we're done. At this point in time, I think we're done. Where I think we are today is that on the one hand, the Commonwealth can enforce the terms of this agreement based on the execution. Mr. Pate, I'm talking at this point in time.
Okay, I'm sorry. I'm sorry.
At this point in time, I'm going to sustain the Commonwealth's motion to revoke his bond. He will be taken into the custody and housed in the Breckinridge County Jail.
Your Honor, if I may speak to Mr. Chambers' motion to revoke the bond.
I've already ruled. I've already ruled at this point in time. We're done at this point in time. He's going into jail today.
Pate eventually pleaded guilty and was sentenced to 75 days in jail, with credit for time served. What's baffling about this is that he really had to push himself to plead guilty. Any normal person would have done it in an instant. This officer could have hurt many people because of what he did, but this next officer did not leave that up to chance.
There's an old saying, it ain't no fun when a rabbit's got the gun. It's equally applicable when he has the video. The eye of justice.
On January 28, 2015, an ex-cop, William Melendez, and his partner stopped Floyd Dent for a minor offense. But this stop turned into something completely different. As William appeared in court, the judge went through the situation again, the details of which will leave you shocked.
January 28, 2015, where his life changed forever. He was stopped by the defendant, a then Inkster police officer, and his partner, Officer Zelenowski. Mr. Dent was stopped for a minor traffic offense and ordered out of his vehicle. With his hands extended out of his driver's window, he was grabbed out, thrown to the ground, and 16 times in the head by the defendant. In his attempt to arrest him, he was thrown onto a window shield of a patrol car. The responding police officers arrived as the defendant is wrestling the defendant to the ground. Mr. Dent was struck, kicked, and tased while on the ground by what appeared to be a group of angry, anxious police officers that celebrated after the defendant was beaten and cuffed. The video in the car shows the police officers fist bumping as a celebratory act of bravery by the defendant and his cohorts. But the one image that struck out to the court was looking at Mr. Dent in his cell, shaking his head.
You could already tell that the judge was infuriated by this devil cop's actions. What he did was so low that even the judge couldn't hide the disgust on her face.
If his conduct was indicative of what he was thinking, I would have thought this. What crime did I commit? Being a black man in a Cadillac, stopped for a minor traffic offense by a group of racist police officers looking to do it. As Police Officer John Zelenowski, auxiliary police officer, testified in court too, in his response to a text, was quoted as saying, "At least give me the satisfaction of knowing that you're out there beating up niggas right now. LOL. How humiliating and degrading that must have been. He was left in a cell for a number of hours before getting medical treatment. On January 28, 2015, you did not fulfill your job. You performed Just Us, a game that began with a police stop. The purpose of it was to harass and degrade a motorist in Inkster. The man chosen for your game was Floyd Dent, a black man. The game went like this. Let's follow a car in a known area, and based on your years of training experience, you knew that the motorist would likely be a black person, no license, armed with a gun or drugs in a vehicle.
The judge was not taking this lightly, as she rubbed the officer's face in the mess that he had created for himself, and you could see the clear indications of shame on the officer's face.
And upon stopping Mr. Dent, who was dead wrong for driving with no license or license suspended, running stop signs, and weaving in and out of the back street, which the court saw on the video. You and your sidekick, auxiliary police officer Zelenowski, caught your prey. Upon being stopped, Mr. Dent put his hands out of the driver's window in plain view. Your partner and you pulled him out. When he didn't move fast enough for you, you refer to it as resisting. I call it bowing down to your command. You utilized your dirty, hairy tactics and used excessive force to arrest him. When your posse arrived, they joined you in the takedown, kicking and ultimately throwing Mr. Dent into a windshield of a police car with a dash cam, which I refer to as the eye of justice. You were so into your bravado that you forgot the eye of justice was watching you and recording this disgusting beating, seeing Mr. Dent slammed into the window shield with blood running down his face. The dash cam that was designed to protect you ended up being what convicted you. Fist busting after taking him down as a sign of bravery was just another cowardly act caught by the eye of justice.
This female judge is what we need more of in this country today. She had no problem at all in stating the obvious and addressing all the elephants in the room.
It took me several days to read the letters that people sent talking about your character, about the man that you are, about how you went in Westland and helped to save 3 senior citizens from a burning building. 3 of those letters, I believe, were from African Americans, and 1 even professed to be like a mother. 1 or 2 things, either they're all racist or there's something redeeming about you that somehow, in some way, you forgot that night. The way you denigrated that man was awful. Who would know and who would care about a lone black man being assaulted by upstanding police officers? At the station, the other eye of justice captured you and your posse making fun of Mr. Dent, mimicking him struggling while you all wiped the blood off your uniforms with disinfectant while he watched. Such an awesome, caring, properly trained police officer. You led your fellow officers down a path of cowardly behavior. But today you will pay for it. You will pay for 2 things. Not being an example of greatness, which I know that you are from all the letters of support, awards, and commendation that you have shared with this court, and resorting to cowardly acts of barbaric behavior that led you to be convicted of these crimes.
After a long verbal beating, the judge finally punished Melendez, and his reaction is worth watching.
You betrayed your city. You caused your lovely wife heartache. And you caused Mr. Dent severe anguish. And finally, in the words of Vicki Yost, your commander, accountability is required to ensure continued community trust and healing. Today, I can only punish your conduct, but only you and God can change your character. I've had an opportunity to listen to both sides, but it was my privilege to be able to oversee this trial because I had great lawyers, and great lawyers make jobs real easy. At this time, I am going to commit you to the Michigan Department of Corrections. However, after weighing the allegations in this particular matter and looking at all the circumstances, including what you've done and who the person I really believe that you are, I'm going to commit you to the Michigan Department of Corrections as to count 1 for no less than 13 months, no more than 10 years. As to count 2, I'm going to give you 90 days credit for time served and close it out. The court's going to give you 85 days for credit. You have 42 days to appeal my decision. That concludes this matter. Thank you.
That day, this judge set an example for how devils like Melendez should be treated nationwide, and I applaud her for that. Moving on to our final sentencing of the day, we have the case of Numan Raja, an evil cop who did one of the worst things a cop could do.
Discharging the firearm actually caused great bodily harm or death to Corey L. Jones.
On March 7th, 2019, Numan Raja, a former police officer from Palm Beach Gardens, Florida, was convicted following an 8-day jury trial for some heinous acts he had committed. On April 25th, 2019, Raja appeared in front of Circuit Judge Joseph Marks, and what the judge did next will leave you shocked.
We got 6 people that were plucked out of their normal lives, just sitting at home eating a sandwich one day, and they got a card in the mail that said, "You got to come to the courthouse." They're just regular folks just like the rest of us. And they got thrust into this situation. I have no idea what's going to happen right now. I do know one thing. There's going to be one side who's going to be brokenhearted. One side's going to be brokenhearted. We know that for sure. What I ask everybody, and then I follow it up with I'm ordering, that I am respectful that this is the most pressure-packed moment for most people in their entire lives. I don't want to hear a peep. And to whatever side's brokenhearted, if you don't think you can take it, I need you to step out in the hallway because there will not be, nobody will run out of this courtroom while I'm taking this verdict. As soon as the 6 jurors are out of the courtroom, you're free to get up, walk out. Please, my job, and I think everybody's picked up on it, how respectful and polite I am to everybody. But when I'm forced to, I bite. I just want peace for these 6 people to get out of here, and then whatever the verdict is, we'll deal with it after they have been excused. Okay. So let's bring in the jury.
After an electric introduction, the judge orders the jury to be brought in.
Jurors, I'm gonna take things out of order here. I want you to listen, one last instruction I have to give to you. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about your work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. When you're being escorted out today, If you want to say, listen, I want to break off and stand in front of the courthouse and talk about this case, you're free to do so. But you're also free to say, I've done my service and I'm leaving. If anybody harasses, I want to know. When you leave, I'm going to give you you're going to be handed a packet. In the packet is a certificate of appreciation. Inside the envelope is a letter evidencing your jury work that I mentioned a very long time ago. If anybody has a problem with an employer, let me know. Also, there's the anonymous questionnaire. It's a way for you to write back to me and tell me, Judge, this is what I liked, this is what I didn't like. Does all of you have your personal belongings? Everything you've gathered, everything up? They're in the jury room? Okay.
You can already tell that this judge is pretty strong on principles. Just think about what he'd do to an officer who has the crime of unaliving someone hanging on his head.
In the Circuit Court of the 15th Judicial Circuit in and for Palm Beach County, Florida, Criminal Division, Division X, case number 2016 CF 005507 AMB, State of Florida, plaintiff versus Newman Khan Raja, defendant, verdict. We, the jury, find as follows. As to count one, we find a defendant guilty of manslaughter while armed with as charged in the information. As to count two, we find a defendant guilty of attempted first-degree murder as charged in the information. If you find a defendant guilty of attempted first-degree murder, you must next answer the following questions. Did the state prove beyond a reasonable doubt that the defendant actually possessed a firearm? Yes. Did the state prove beyond a reasonable doubt that the defendant actually discharged a firearm? Yes. Discharging the firearm actually caused great bodily harm or death to Corey L. Jones? Yes. So say we all, the 7th day of March, 2019, in West Palm Beach County, Florida, signed, jury, foreperson.
Poll the jury.
Juror number one, were the verdicts is read your verdict? Juror number two, were the verdicts is read your verdicts?
Yes.
Juror number three, were the verdicts is read your verdicts?
Yes.
Juror number four, were the verdicts is read your verdicts?
Yes.
Juror number five, were the verdicts is read your verdicts?
Yes.
Juror number six, were the verdicts is read your verdicts?
Yes.
Thank you very much. You're excused. Follow the deputies. All right, everybody have a seat.
Even the jury seemed determined to put the devil cop behind bars, but now it was the judge's turn to speak.
All right. So, State, what are your feelings? 30 days to put it off?
At this time, obviously, we're going to request that the defendant be remanded.
I am going to remand the defendant.
We will, we understand that there realistically is going to be some type of legal argument that needs to be made.
Sure.
Based on the verdict, we would expect there to be some type of motions filed by the defense. We'd ask the court, if you would, set a deadline on filing motions and then give us a certain deadline on responding to those motions and then setting a sentencing hearing either from that point, but I think 30 days might be a little too light, just in the fact of understandably there probably will be some litigation prior to the actual.
I'm sure. Definitely there will be, based on some previous discussions we had. Should I pass sentencing off then for about 45 days to get your post-trial motions in order? Okay. So, Ms. Driscoll, please give me a date in about approximately 45 days, and I'll set it at 1:30 in the afternoon and set aside the whole afternoon.
We also have a date, just a final date for any motions to be filed. That will give us an opportunity to file.
I'll put that at the 30-day mark.
Yes, sir. Thank you.
So that gives you 15 days in between. 30 days to get your appropriate motions filed, 15 days early.
Judge, are you going to do the motions at the same time as the sentencing?
That would not be my intention. That would not be my intention. So I'll have time in between there. The lawyers have worked so well together. Just contact each other, and I'll put aside special time for you. April 26th, that's the 45-day mark. Okay, that'll be sentencing, 1:30 in the afternoon, and in between, I'll leave it to the lawyers to contact my office to set up whatever hearings need to be conducted regarding post-trial motions. I hereby remand the defendant. And Mr. Lubin, do you want a PSI?
The court was dismissed afterward, but on April 25, 2019, the same judge, Joseph Marks, sentenced Raja to an astounding prison sentence.
On count 1, I hereby sentence him to 25 years in the Department of Corrections. And on count 2, I hereby sentence Mr. Raja to 25 years in the Department of Corrections. That is as a minimum mandatory, which was required that he serve day for day. Those sentences will run concurrently.
Raja's scheduled release date is February 27, 2044, but under Florida parole and probation guidelines, his minimum release date is May 29, 2040. As of September 20th, 19, Raja was being held at the Wakulla Correctional Institution in Crawfordville, a minimum to medium security level prison southeast of Tallahassee.
Next, the spotlight shifts to an officer convicted of violent misconduct. At first, he fights to keep his composure, but as the sentence is read, you can see the disbelief wash over him.
Everything. Turn off the vehicle. Turn off the vehicle. Turn it off. Turn off the car. Turn off the car. Sir, turn off the vehicle. Turn off the vehicle, sir. Turn it off. Turn off the car and roll down the window. Open the door. Get me that other unit. Open the window. Open the door.
What's up?
I got a 646. Let me see your hands. Let me see your hands. Hands. Hands on the wheel. Let me see your hands. Let me see your hands. Hands on the wheel. The car's off. Be advised, the vehicle took off. Thomason, Pennsylvania. 2017, Chrysler 300, color black. Zulu 21, hotel, kilo. It should be under his leg.
Does anybody fires a weapon here?
No, here, not here.
Delta 91, go. I think you're in start moving these cars so the bus can get built.
When the lady officer told Griffin to stop, Griffin rolled up the window, making things worse by resisting arrest and endangering everyone. Meanwhile, the cop was running and shooting, which was reckless and unprofessional, putting public safety at risk. At the Newark courthouse, emotions were intense as former officer Giovanni Crespo was sentenced to 27 years in prison for an incident from January 2019. Crespo was convicted of aggravated manslaughter and official misconduct. During the hearing, his family and the families of the two victims sat on opposite sides, both seeking justice. In July 2018, Crespo was found guilty and apologized to the court for the pain he caused both families.
When I got to Giovanni, I made a promise to his mom that Giovanni was going to be the best that he could be. And she wanted me to raise him the right way, and I did my best.
I would just like to apologize for the event that occurred. to the victims, to my family that I put through, everybody that been going through hard times because of this. I took a chance at a job where it's life or death every day. And the thin blue line really is just the line.
Court's decisions can often take your burdens away, just like this next verdict where the cops seem to shed a huge amount of allegations.
The defendant is not guilty. So say we all this 29th day of June, 2023 at Fort Lauderdale, Broward County Court.
Scott Peterson, the armed school officer during the 2018 Parkland, faced major backlash after 17 people were killed and 17 others injured. Accused of abandoning his post, he failed to investigate the fire, retreated as the shooting unfolded, and even ordered other officers to stay away.
Okay, the verdict forms are complete. I will now publish them. They read as follows. In the Circuit Court of the 17th Judicial Circuit in and for Broward County, Florida, case number 19-7166 CF10A, State of Florida plaintiff versus Scott Peterson defendant, verdict, count 1. We, the jury, find as follows as to the defendant in this case. The defendant is not guilty. So say we all this 29th day of June 2023 at Fort Lauderdale, Broward County, Florida. Verdict, count 2. We, the jury, find as follows as to the defendant in this case. The defendant is not guilty. So say we all this 29th day of June 2023 at Fort Lauderdale, Broward County, Florida. Verdict, count 3. We, the jury, find as follows as to the defendant in this case. The defendant is not guilty. So say we all this 29th day of June 2023 at Fort Lauderdale, Broward County, Florida. We, the jury, find as follows as to the defendant in this case. The defendant is not guilty. So say we all this 29th day of June 2023 at Fort Lauderdale, Broward County, Florida. Verdict, count 5. We, the jury, find as follows as to the defendant in this case. The defendant is not guilty. So say we all this 29th day of June 2023 at Fort Lauderdale, Broward County, Florida. Verdict, count 6. We, the jury, find as follows as to the defendant in this case. The defendant is not guilty. So say we all this 29th day of June 2023 at Fort Lauderdale, Broward County, Florida. Verdict, count 7. We, the jury, find as follows as to the defendant in this case. The defendant is not guilty. So say we all this 29th day of June 2023 at Fort Lauderdale, Broward County, Florida. We, the jury, find as follows as to the defendant in this case. The defendant is not guilty. So say we all this 29th day of June 2023 at Fort Lauderdale, Broward County, Florida. Verdict, count 10. We, the jury, find as follows as to the defendant in this case. The defendant is not guilty. So say we all this 29th day of June 2023 at Fort Lauderdale, Broward County, Florida. Verdict, count 11. We, the jury, find as follows as to the defendant in this case. The defendant is not guilty. So say we all this 29th day of June 2023 at Fort Lauderdale, Broward County, Florida. Ladies and gentlemen, I'm going to address you only by the numbers that are on the back of your badges. Juror number 1, are these your true verdicts?
Yes, they are.
Juror number 2, are these your true verdicts?
Yes.
Juror number 4, are these your true verdicts?
It was clear Peterson had been suffering since the tragic loss of those innocent lives, replaying the event in his mind over and over. He couldn't escape it. In the end, the jury did their job and got it right.
Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to each of you to decide whether to preserve your privacy as a juror.
99% of the citizens that live in Broward County, a county of 2 million, have no idea what happens when you're actually selected on a jury and you actually serve through the process. But now you all know. And I know most people don't say thank you, but I will say thank you because I know the time, effort, and energy that went into this. I have a thank you letter and a certificate. I'm going to give that to the court deputy who's going to pass that out when they walk you out because it has your names on them. The reason I normally do this in person in the courtroom, but I'm not going to do it today, is because I'm not and have not addressed you by your names. That's why we use the numbers in care of your privacy. I did also want to let you all know I will be entering an order today that instructs the clerk of court, the trial court administrator, as well as both parties not to disclose your names, okay? So the only way your names are going to be disclosed is if you choose. You certainly may choose. So if you want to go out there and talk to whoever you want to talk to, you're perfectly entitled to do that. Since you actually did serve on a jury, they will not summon you for jury duty for a year, for 12 months. So I'll see you next year. All right, unless you all have any questions for me, ladies and gentlemen, your jury service is concluded at this point. Again, with my great thanks for your time, effort, and energy, Court Deputy, there's a certificate for each. Your jury service is concluded and you are dismissed. Thank you very much.
The district attorney tried to pin their broken system on Peterson, making him the scapegoat. But Peterson wasn't guilty of murder. It wasn't his fault.
Okay, we're outside the presence of the jury. Everyone can be seated. I do need to address with all parties. I am entering an order contemporaneously. Madam Clerk will have a copy for each of the lawyers, order sealing juror information. This order is specifically directed at our trial court administrator, at the Broward County Clerk of Courts, as well as the state and as well as the defense. I'm going to have the jury verdict forms redacted. The jury information is going to be sealed. So I'm likewise ordering the state and ordering the defense not to disclose any of those names. In this age of electronic multimedia, I'm sure if any jurors would like their identities to be revealed and would like to speak to media or other sources, I'm sure they will have ample opportunity to do so. But that's not going to come from the state, and that's not going to come from the defense. Ms. Wilcox, you have copies of those orders for each. The jury having found you not guilty on counts 1 through 11, I will likewise enter an order of acquittal as to counts 1 through 11. Mr. Eilgosh, is there anything you need me to do regarding Mr. Peterson? No, Your Honor. I wish you good luck, sir. State, anything else you need me to do? No, thank you. Okay. Then at this point, that's going to conclude the proceedings in 19-7166 CF10A. All right, Madam Court Reporter, that is it.
It was such a relief to see Peterson cleared of a crime he didn't commit. People were quick to blame him for a psychopath school shooting. But in the end, justice was rightly served. Peterson was hit with charges of child neglect, negligence, and lying, facing several years in prison. But after a long trial, he was found not guilty of everything. When the verdict came, Peterson cried with relief. Being in authority means managing to keep personal emotion, unlike the next cop who did his best to mix them up.
There were no winners at all in this situation, not only for myself and my family, but for all of those involved.
Michael Notariano was sentenced to 6 months in jail for his role in a violent clash with Detroit men who had stolen his daughter's phone. Despite being a former police officer, Notariano only faced 1 misdemeanor charge after a jury cleared him of 10 others, including armed robbery and racial intent. The judge rejected probation, deciding instead to impose jail time. In 2018, Notariano was found guilty of willful neglect of duty for pointing a gun and using racial slurs in a 2013 incident. The judge noted that racial prejudice seemed to be part of Notariano's character, leading to a stricter sentence. Being effective is part of the job, but sometimes it comes with a steep price, just like in this next case.
This is punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days.
In 2019, a neighbor called for a wellness check at Jefferson's mother's home, where Jefferson was watching her nephew. Officer Aaron Dean, a 38-year-old white officer, responded and shot 28-year-old Jefferson through the window. He resigned before being fired for policy violations. Jefferson's 11-year-old nephew, who was then 8 years old, witnessed the shooting as he was in the same room and testified last week.
Afternoon. The jury has sent a note or given me notice that they have reached a verdict. Are both sides ready to receive the verdict?
State's ready, Your Honor.
All right. Y'all did fabulous when we did the guilt-innocence verdict, okay? Same rules apply. I don't know what this verdict is. Can't have any emotions, all right? Let's bring them in. Okay. Everyone may be seated. Good afternoon. Juror number one, it's my understanding the jury has reached a verdict. Is that correct? Is it a unanimous verdict? Okay. And please, Deputy Nicholson. Mr. Dean. Verdict reads, we the jury, having found the defendant Aaron York Dean guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days. They do not assess a fine, and it is signed by the presiding juror. You may be seated. Thank you very much.
What Dean did was deeply inhuman and shameful. His unprofessionalism and lack of training led to the kill of an innocent person.
Juror number one, is this your verdict? Juror number three, is this your verdict? Juror number four, is this your verdict? Juror number six, is this your verdict? Juror number 9, is this your verdict? Juror number 14, is this your verdict? Juror number 15, is this your verdict? Juror number 21, is this your verdict? Juror number 31, is this your verdict? Juror number 32, is this your verdict? Juror number 37, is this your verdict? Juror number 38, is this your verdict? Your verdict will be received and filed. Thank you very much. Mr. Dean, it's the jury having found you guilty of the offense of manslaughter and assessed this punishment. It's the order of the court you be remanded to the custody of the sheriff, be delivered to the director of the Texas Department of Criminal Justice to serve your sentence as required by law. You will receive credit for all the time that you have served in custody on this case from the date of your original arrest up until today, which would be the date of sentence. You have the right to appeal the jury's decision. You do so by giving written notice of appeal to the Second Court of Appeals here in Fort Worth within 30 days. If you are indigent and cannot afford a lawyer, I would conduct an indigency hearing to determine if you are indigent. And if you are indigent, I would appoint a lawyer to represent you on appeal and provide you a record of this appeal of this trial at no cost.
Dean deserved a much longer sentence than just 11 years for his actions. Still, justice was served and he faced punishment for his crime. A jury convicted Aaron Dean of manslaughter. He was sentenced to 11 years, 10 months, and 12 days in prison. The judge also noted that Dean could be eligible for parole after serving half of his sentence. Even though a cop's job is hectic, losing your temper and acting recklessly isn't acceptable. Yet that's exactly what the next cop did.
The jury unanimously find the defendant, Amber Geiger, guilty of murder as charged in the indictment.
On September 6, 2018, Amber Geiger, a fired Dallas police officer, and Botham Jean in his own apartment, mistakenly thinking it was her own. The verdict came down with her being found guilty of murder. Inside the courtroom, gasps echoed as Geiger wiped away tears, and outside, supporters of Jean celebrated. Facing a possible 10-year sentence, Geiger's family looked stunned. Despite her emotional testimony claiming it was a tragic mistake, her defense plans to appeal for a reduced charge of aggravated. The verdict is seen as a significant win in a racially charged case, with Jean's family and supporters viewing it as a victory for justice.
The charges in this case were first-degree murder, 16 counts of aggravated battery, and 1 count of official misconduct.
On October 20th, 2014 in Chicago, 17-year-old Laquan McDonald was fatally shot 16 times by Officer Jason Van Dyke. Initially, police claimed McDonald was threatening them, but a dashcam video released over a year later revealed he was walking away when Van Dyke fired. This shocking footage exposed the false narrative and ignited widespread outrage.
Who have taken the time out of their life, and we all know just come back from a small vacation or some kind of work trip, how we have to catch up, and they have to catch up. And they've done things, and this is not the easiest decisions to make in the world. So I don't want anybody second guessing them. They've done an outstanding job. We all have to be proud of their accomplishments as citizens of Cook County. So again, what I want you to do is look into your heart. And if you can withstand the verdicts, please stay. But if you think you can't, I want you to leave, because there will be a zero tolerance at this time. Because I'm not going to have these people disrespected. And thank you, ma'am, I appreciate that. I know this isn't going to be easy, so I'm, asking you again to look into your heart. If you think you're not capable of this, then please leave, and we'll let you back in after the verdict. All right, we all ready? And I want to, all right, what I want to do too is we've had members from the media, both broadcast and press journalists. They've just been fantastic. Everybody's been really outstanding. The reporting on this has been very important because we need transparency, and especially a case like this. And I really want to compliment the media chairs. They've just been great. They've been very cooperative. We had a great session the other day with the two jurors, the alternate jurors that were excused, and we're allowed, to have the interview with them.
Jason didn't merely shoot Quan McDonald 16 times, he murdered him. It didn't matter who McDonald was or that he was a black teenager. The key point was the sheer brutality of the excessive force used.
Again, thank you very much. I appreciate your interest, and again, thank you for the press. You've been outstanding. All right, bring the jury out, please.
All rise for the jury.
Will the foreperson please rise? Has the jury reached verdicts?
Yes, they have.
Thank you very much. Could you give Jessica the jury verdict forms and just have a seat? Appreciate that. I like your jury. You're wearing them like necklaces. Fantastic. That's good. Ladies and gentlemen, let me explain certain things so you'll understand the verdicts a little bit better. All right, the charges in this case were first-degree murder, 16 counts of aggravated battery, and 1 count of official misconduct. There also, the defense had asked for the instructions and the jury verdict form on second-degree murder. All right, let me explain the process here. Before anybody can get to second-degree murder, the state must prove each and every element of first-degree murder. There is no bypassing that and going directly to second-degree murder. As pointed out by one of our wonderful professors, Professor Kling, who's in the audience during his lectures, second-degree murder is a combination of first-degree murder plus a mitigating factor.
The entire department, including the chief and mayor, should have been charged along with Jason. Their unprofessionalism and negligence in putting unfit officers on duty made them responsible for the murder. It was a larger crime than just Jason's actions.
We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, 8 shots. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, 9 shots. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, 10 shots. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, 11 shots. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with firearms, 12 shots. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with firearms, 13 shots. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with firearms, 14 shots. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with firearms, 15 shots. We, the jury, find the defendant, Jason Van Dyke, not guilty of official misconduct. 12 signatures.
At this time, Mr. Herbert.
Judge, please do not hold the jury.
Can I have the attorneys over here for a second, please?
It was shocking that, of all the cops at the scene that night, he was the only one who fired his gun. That said it all. He definitely needed to be punished for his actions.
Mr. Herbert.
Your Honor, this time we'd ask to hold the jury.
Ladies and gentlemen, I know this is, a new experience for you, but when anybody has been convicted of a criminal offense in the state of Illinois by a jury trial, the person that has been convicted has an absolute right to hold the jury. This was a remedy decided by our Illinois Supreme Court. And the purpose of this is in case somebody was forced to sign a jury verdict form in the jury room. And this gave that individual the opportunity to be in the public and say, no, this wasn't my verdict form. So it's an absolute right. So the question will be, was this then and is this now your verdict? Meaning, was that then in the jury room and is this now your verdict? So at this time, Tony?
Yeah. Juror 241, were those then and are these now your verdicts?
Yes.
Juror 242, were those then and are these now your verdicts?
Yes.
Juror 243, were those then and are these now your verdicts?
Yes.
Juror 244, were those then and are these now your verdicts?
Yes.
Juror 245, were those then and are these now your verdicts?
Yes.
Juror 246, were those then and are these now your verdicts?
Yes.
Juror 247, were those then and are these now your verdicts?
Yes.
Juror 248, were those then and are these now your verdicts?
Yes.
Juror 249, were those then and are these now your verdicts?
Yes.
Juror 250, were those then and are these now your verdicts?
Yes.
And juror 251, were those then and are these now your verdicts?
Yes.
Thank you.
Okay, John and Jessica, will you take our wonderful people of the jury and our three wonderful alternates back to the jury room, please?
All rise for the jury.
Such cops should face stiffer sentences, like life in prison or the death penalty, to deter future brutality. Sadly, even after his verdict, he showed no remorse or reaction at all. He was a clear psychopath. Van Dyke faced first-degree murder charges and was held without bail before being released. The city settled with McDonald's family for $5 million. On October 5, 2018, Van Dyke was convicted of second-degree and 16 counts of aggravated battery. He was sentenced to prison in January 2019, but got out early for good behavior in February 2022. And finally, a cop was found guilty of severe abuse of power when he assaulted a black driver. The courtroom is silent as he realizes there's no escape this time.
Interesting that the state is making the argument that the stop is a separate offense than the assault, because Mr. Amiat was not charged with a violation of any crime for the stop. The interfering with civil rights lays out the facts supporting that charge in the charging document, which is the assault. It mirrors the exact same language. The jury instruction mirrored the exact same language. And so the state now asks this court to sentence Officer Amiat separately for conduct which he was not charged for, which he has not been afforded due process for, and which would be in violation of his constitutional rights.
It is intriguing how Amiat was not initially charged with any crime until Hubbard came forward.
I proceed.
My name is Richard Hubbard, and you know I appreciate the jury and the court for making the right decision. You know, what Amy did to me was wrong. He should have received the maximum sentences today. You know, I'm still going through like the suffering with the anxiety, you know, driving, just the temperament, the trauma, and everything. This is a cause for this case. I'm ready to get it over it actually, but just coming back in here just like bring up everything. You know, just to see him over there, you know, see all that, just coming back in this court, just like it just brings up everything. Like we live at the moment. So you know, I hope he gets the maximum sentences today.
The pain in Richard's words is evident. The officer caused him so much pain. Next, we hear the statement from the officer, and it appears he showed little remorse.
Good morning.
Good morning.
Thank you to the court for allowing me a few minutes to speak. It's been a long road. I was 31 years old at the time of this incident. I'm 37 today. As I get older, I tend to put things in perspective more. We're all molded and shaped by our experiences in life and the outcomes of those experiences.
Following his emotionless and lengthy speech, the court finally delivers its judgment.
Mr. Hubbard, let me say to you, it's been 7 years. The city of Euclid compensated you. If you need assistance, you need to go and get that assistance. But I'm not going to say you're not going to have instances of flashback or what have you, but you need to move on with your life also. And not let this incident continue to hover over you.
The judge provided prudent advice to Hubbard, suggesting that he seek assistance if necessary and endeavor to release the memories associated with the event.
The evidence presented and the pre-sentence investigation. The court at this time will impose a sentence of 90 days, require you to pay a fine of $1,000.
The court's decision reflects the severity of the harm caused by this law enforcement officer. Next, we examine the case of a law enforcement officer who neglected his duty to protect. At Tonawanda City Courthouse outside Buffalo, New York, a heated conversation between a couple alerts Tonawanda City Cop Michael Lewandowski. He approaches them, saying they should leave, but they refuse. Another officer tries to intervene, and in seconds, Lewandowski loses it and forcefully pulls the man out of his seat into the hallway. Outside the hall, the camera shows Lewandowski attacking the man who's trying to battle with another officer. The woman, seeing this, tries to intervene, but the cops push her against the wall, causing her to hit her head. This doesn't stop her as she begins to scream at the officers. After forcibly removing the couple from the courthouse, Lewandowski proceeded to handcuff them and escorted them out without any charges. Lewandowski was later suspended for 5 days for the use of unnecessary force. 4 years later, a local news outlet released the footage of the incident, leading to Lewandowski's termination from office. Next up, one of the worst cops in history finally faced justice.
Yes, my friend Melissa said she's going to get a hold of her friend Joe. Okay, well, put it this way. You got it wrong. Less than 5 minutes for her to make that decision. If not, I'm going to end up probably impounding your car and you can go to his house, okay? Oh my God, please. All right?
In June 2016, a former Covert Township police officer, Eric Fritz, pulled over a woman, Melissa McMillan, and her driver for drunk driving.
All right. Come on with me. Come on, Melissa. I need you to hop out. Yes, sir. Let me get my stuff. You got everything? Yes, I'm okay.
Observing that Melissa was intoxicated, Eric decided to take her to a hotel instead of getting her a ride home. Melissa, trusting that he, as a police officer, would protect her, agreed.
What your first recall is after leaving Captain Lou's?
It's so hard to remember because everything is so blurry and being on the side of the road.
You do remember that?
Very, very vaguely, yes.
Lay down in one of the beds that was in that room?
Yes.
Okay. And do you remember doing that, or?
No.
Okay. Did there come a point in time, or do you have any memory of the officer returning to the hotel room?
No.
Okay. When is your next memory of seeing the officer there in the hotel room, if at all?
The next memory I have is he was on top of me, having intercourse.
Melissa accuses Officer Fritz of raping her in her drunken state, but the latter claims it was consensual. Fritz was later arrested and charged with kidnapping and 2 counts of criminal assault. In this next clip, we get to witness the consequences of his actions as he faces justice.
And sir, you are Eric Fritz?
Yes, Your Honor.
And you're here today with your attorney, Mr. Grable. Have you had a full and complete opportunity to consult with him?
Yes, Your Honor.
And you understand that you face today a possible maximum penalty of 15 years in prison?
Yes, Your Honor.
Knowing he might face up to 15 years in prison must have been good news to the victim and her family. But Fritz doesn't seem to care, and he tries to remain composed.
As a police officer who took an oath to protect and serve the community, what you did to me was wrong. You raped me. You knew I was highly intoxicated, yet you used that as a selfish opportunity. My life has been forever changed. Every aspect of my life has been affected. My children have struggled. My friends, family, and loved ones have watched me through a year of hell. I can't see a police vehicle without feeling fear or be reminded of what happened.
The actions of this cop have affected the victim so much. There's nothing scarier than having those who are meant to protect you turn their backs and hurt you.
Yes, Your Honor. First, I'd like to apologize to my friends and family who I've actually let down. I'd also like to apologize for my coworkers who I embarrassed by my decisions. I'd also like to apologize to the people of Clover Township for my actions that night. And I absolutely would like to apologize for Ms. McMillan for my horrific decision of offering her a hotel room. I never should have offered her a hotel room in the first place. It never should have. I never should have put her in that situation.
At least this cop knows his actions are embarrassing and is now taking account of his actions.
You took a law enforcement oath of honor to protect and to serve and to uphold the highest of ethical standards. Instead, you preyed upon and exploited and damaged a woman who was entirely helpless due to excessive intoxication. Even more disturbing to this court is the fact that you used your badge and the authority and power it grants you as a means to implement your criminality. You betrayed her, you betrayed your fellow officers, you betrayed mightily the public trust all of us had in you.
At the conclusion of the court session, Fritz received a sentence of 1 year in county jail, followed by 5 years on probation. Although this consequence may not fully repair the harm experienced by the victim, it serves as a reminder that justice is impartial and that everyone is accountable for their actions, regardless of their status. These cases serve as a powerful reminder that even those sworn to uphold the law are not above it. Unfortunately, incidents like these are not isolated. Just like this officer who thought his badge would let him escape the consequences of his actions. Click here to watch how he was dealt with, because this story is about to take a shocking turn you won't see coming.